Good morning, and welcome to the last day of Supreme Court Week here at Woodward Academy. We're seated here in Gresham Chapel at WA Live Court TV edition. By now, you all should be familiar with the process of what's going to go on here. We're going to hear two new cases today. The first case is called Florida v. Harris, and the second case is called Florida v. Jardins. I am flanked to my left in the studio by former ACLU attorney, Ms. Maggie Berthume. I'm flanked to my right here by former U.S. attorney, Mr. Bill Batterman. They will be providing color commentary to these cases beforehand, and then we will have the actual Supreme Court cases with the student attorneys litigating their matter before the Supreme Court. And then afterward, we'll cut back to the WA Live Court TV studio, in which we will provide some post-case analysis. Now, the people who are seated in our gallery audience are able to participate by, and as well as the people who are in TV land are able to participate by chatting with me live while the cases are going on at todaysmeet.com/BKJ. So that would be todaysmeet.com/BKJ. Please feel free to chat with me live, and I will respond to you as soon as I possibly can. All right, now without further ado, let's go back to let's go back here and talk about these two cases. All right, now let's talk first with Ms. Berthume. Ms. Berthume, will you please talk about these two cases, as it seemed that they both involved Florida and dog sniffing?
That's absolutely right. These are two cases about the use of drug-sniffing dogs in Florida. And drug-sniffing dogs is an issue the Supreme Court has confronted before. There are three precedent cases that are quite relevant to the discussion today. In 1983, in United States v. Place, the Supreme Court ruled that a drug-sniffing dog isn't a search under the Fourth Amendment.
And why is that?
Because a search, according to the Supreme Court, a Fourth Amendment search requires a police officer to investigate to find legal or illegal material. And a drug-sniffing dog, they ruled, is unique in that it only encounters or discovers illegal material.
Okay.
They upheld this decision in City of Indianapolis v. Edmond, and then once again in Illinois v. Cabayas, the most recent case, in 2005, which says that it is lawful to use a drug-sniffing dog during routine traffic searches.
Okay, all right. Now, Mr. Batterman, since you are a former government attorney, how do you think these cases are going to come out?
Well, there's two issues that the court has to decide. In Florida v. Harris, they have to decide whether a drug-sniffing dog's alert constitutes probable cause, and whether the dog needs to be well-trained, and whether a well-trained dog can produce probable cause. And in Florida v. Jardins, they have to decide whether the ability of the police to use a drug-sniffing dog extends not just to a car or an airport or other public area, but to an individual's home. The court probably is not going to overturn its decision that a drug-sniffing dog constitutes a search. I don't think that there's really any chance that they'll say that it's a search. They might decide that there are some limitations on when a drug-sniffing dog can be used. If I was handicapping the cases, I would say that Florida is likely to win the Harris case because the court will not want to limit law enforcement's use of drug-sniffing dogs, but that Jardins might win his case because the court will want to protect the sanctity of individuals' homes.
All right, now, both of you, let's talk about this now. As I understand the two cases, the Florida versus Harris case involved a drug-sniffing dog sniffing a car on a public street highway. In the Jardins case, it involves Florida using a drug-sniffing dog to sniff someone's private residence. Do you think the court may or may not make a distinction in terms of the individual's right to privacy on a public street/highway versus the right to privacy in someone's private home?
I think for sure that they will likely make that distinction. The reason is that the court, and especially the conservative justices, John Roberts in particular, has come out strongly in previous cases about the sanctity of a person's home and how the standard of privacy or the expectation of privacy is greater in an individual's home versus an individual's car or other entity in public. So I do think that distinction has precedent supporting it, and I do think the court is likely to resolve these cases differently on that basis.
All right. Do you have the same analysis, Ms. Berthiaume?
I strongly agree. The court has long upheld a higher standard for searches or other investigative techniques outside homes. They ruled that heat-seeking detection is not allowed to be trained at someone's home, does not constitute a legal search. So I agree with Mr. Batterman that it's very likely that they will come down on the side of Jardins in that case.
Okay, well, you know what? We'll see what the actual lawyers argue, and we'll see what the actual Supreme Court decide, as I understand that they are getting ready to proceed into the courtroom. So we're going to turn our attentions away from WA Live Court TV studio, and we'll turn our attentions directly to the courtroom as they process to hear these two cases, Florida versus Harris and Florida versus Jardins. Thank you for watching.
The United States Supreme Court is now in session. The Honorable United States Supreme Court Justices presiding. The two cases on the docket are Florida versus Harris and Florida versus Jardins.
You may all be seated. So our first case this morning will be Florida versus Harris. Is the attorney for the state of Florida ready to proceed? And is the attorney for Harris ready to proceed? Okay. At this time, the attorney for the state of Florida may approach the podium. You have the court's attention.
My name is Michelle Harlan, and I will be the attorney representing the state of Florida in the case Florida versus Harris. The case begins with a man named Clayton Harris. Harris was pulled over by the Florida Police Department for driving with an expired license plate, but Deputy Wheatley found more than he expected. He describes that Harris was very nervous when he was pulled over and that he was shaking. Wheatley detected an open bottle of alcohol in the cup holder of the car. Harris knew that his plate was expired but would not let the police search his car because he did not think that probable cause would suffice. Deputy Wheatley returned to his car and brought back his trained narcotics detection dog, Aldo. Aldo is trained to detect crack, cocaine, methamphetamine, and other illegal drugs. Aldo detected something on the inside of the car on the driver's side. Harris was asked to leave his car so that it could be searched. Deputy Wheatley found 200 loose pseudoephedrine pills concealed in a plastic Walgreens bag. He also found 8 boxes of matches, totaling in 8,000 matches. Lastly, he found a bottle of muriatic acid, antifreeze water remover, and a green latex glove that held iodine in it. These are the key items in making homemade methamphetamine. Deputy Wheatley read Harris's Miranda rights and then arrested him for making meth. Harris then confessed that he went to many different grocery and drug stores to buy the items to make meth. He also announced that he had been cooking meth for a year and that he is addicted and cannot go more than a few days without taking it. The amendment for this case is the Fourth Amendment. The Fourth Amendment protects all laws of privacy. It protects against unreasonable searches in your house, car, papers, or anything else that no warrant is issued for. In my case, the Florida Supreme Court believes that the deputy had a reasonable cause for a warrantless search. His cause was that the narcotics detection dog is such a reliable source for the totality of circumstances. This means that the Florida court believes that the reason for the search had probable cause because the trained and certified narcotics detection dog was alerted when searching the car of Clayton Harris. My case begins with proving that there was probable cause for searching Harris's car. Probable cause can be established when the officer claims that the search dog is trained and certified. Even though in the Constitution it does state that there must be a warrant, on many occasions the Supreme Court has questioned the meaning of probable cause. The Supreme Court states that as long as there is a foundation for belief of guilt, then the officer has the right to search or seize the subject as long as the subject was told that he or she is suspected to be guilty. The probable cause for this case was the expired license plate, Clayton Harris being nervous, the open bottle of alcohol in his car, the fact that he would not let the police search his car, and the dog do create probable cause. The law states that persuasive regulation of vehicles capable of traveling on the public highways, probable cause is suffice to justify the search of a vehicle even in the absence of a warrant. Thank you.
So I follow the public street argument, and I also understand the probable cause because of behavior, erratic behavior. But help me with probable cause based on an expired license tag or refusal of searching. How does that help to establish probable cause?
Well, because Deputy Wheatley was suspicious because Clayton Harris was nervous and he had an expired license plate, and he wouldn't let the police just do a simple search of his car. So he decided to go back and get his narcotics detection dog just to search around the car, and the dog did indeed smell something and alert.
Would you be nervous if a police officer pulled you over?
No, Your Honor.
You would not. I would be. Justices? Comments?
How do you know the dog's reliable?
Well, the dog was trained. The dog was trained in Apopka, Florida. He completed a 120-hour training, and he also completed a 40-hour refresher training, and he passed his proficiency test. So there are many papers that say that he is trained and certified.
Any other questions? Thank you. You may be seated. And if the attorney for Harris would approach the podium, you have the court's attention.
Hi, my name's Sarah McKinney, and I represent the defendant Clayton Harris. The main topic of this case is to determine if the alert of the drug detection dog is enough probable cause to search a citizen's car without a search warrant. Clayton Harris was stopped by police officer William Wheatley during a routine traffic stop on June 24, 2006, due to an expired license plate. Harris refused to let the officer inspect his car, based on his right found in the Fourth Amendment against unlawful search and seizure. However, the officer was accompanied by a canine unit drug detection dog, Aldo, who searched the exterior of the car even though a search was refused. Aldo signaled to the officer that he had detected the scent of drugs, most likely a residual scent, on the front left door handle of Harris's car. Wheatley decided that Aldo's indication was enough probable cause to lawfully search the truck without a search warrant. The officer searched the inside of a car and found 200 capsules of pseudoephedrine, a common household and legal drug. Clayton Harris was fined for an expired license plate tag and charged with the possession of pseudoephedrine capsules in the intent of using them to make illegal drugs. What I ask of this court is to remove the charges against my client, Mr. Harris, because the search of my client's car was completely illegal and the officer's decision to search the car anyway violated my client's Fourth Amendment right against unlawful search and seizure. The officer's assumption to search the car according to the indication given by his canine, Aldo, was a violation of the Fourth Amendment right against unlawful search and seizure for many reasons. One reason that the indication of Aldo was not enough probable cause to search the car was the dog was 18 months behind on his recertification for active and accurate field duty. The dog did have training records, but did not, however, have any record of car searches that he executed. In order to maintain enough probable cause to search the car, which is required by the 14th Amendment, it is only right to have records of accuracy of the dog on file. The dog's officer, William Wheatley, did not keep records of the dog's searches unless he had indicated the presence of a substance and had been right, which are very few cases. Harris's initial traffic stop was not even in the small amount of records that he did hold. No illegal drugs were found in the car, so the only sure reason that Aldo alerted his officer of drugs on the door handle was that there was a residual scent. The odors that the drug dogs are trained to sense end up being residual scents most of the time. The scents could have still lingered from months, even years, before the initial search date. It is just nearly impossible to tell the dog's indication of how long the scent has been there. A third reason that the officer and his dog are not accurate in the arrest of the citizen is there was no illegal substance found in the vehicle. This was a false alert by Aldo because no illegal drugs were found, so the law concludes by way of the Fourth Amendment that this search was against the law. Pseudoephedrine is a common household drug used for allergy relief. This product is commonly purchased in 100-count quantities, so 200 capsules is not an alarmingly large number of medicine. Another reason that ties into the evidence against the officer and his canine is Aldo is trained to detect certain drugs: cannabis, methamphetamine, cocaine, and heroin only. This brings me to deduce that the dog could not possibly have smelled the pseudoephedrine on the door handle because it wasn't even trained to detect pseudoephedrine or anything else that was found in the car, which is more reason supporting Harris when he says that this search was against the law by way of the Fourth Amendment. For even more emphasis, the same scent was detected by Aldo on a second traffic stop when nothing was even found in the car. The scent found by Aldo on the door handle was definitely not the pseudoephedrine, and the officer most definitely did not have the right to search the car because his dog was not proven accurate enough to be considered as probable cause as found in the Fourth Amendment.
So, do you believe that a person has a right to expect privacy when they're on a public street in terms of search?
I do.
At what point in time would probable cause give an officer the right to search that vehicle?
I think I can tell you what I don't think. I don't think that an expired license plate tag gives him the right to search for illegal drugs in the car because those have no relation. I mean, he could have ordered his license plate tag a month ago and it hadn't been there. I mean, there are many circumstances that we're facing in this decision. And illegal drugs and the expiration of a license plate tag don't have any relation, in my opinion.
Thank you. Justices?
When was the last time the dog was checked up? Is there any problem with the dog at all?
He was 18 months behind on his recertification, which made him technically unfit for active and accurate duty. Thank you.
Okay, thank you for your time. Would the attorney for the state of Florida like to rebut anything? Please take the podium.
First off, I like to state that the dog search is not a real search because it is on public property. So when Clayton Harris said that we were not allowed to search his car, it was wrong because it wasn't private property. And it is never stated in the Florida laws or in any law that a dog must have a yearly certification test. Aldo is a certified dog, and he was trained by the facilities in Apopka, Florida. The police did not know that the drug inside the car was legal until they went inside the car to investigate. However, pseudoephedrine's legal maximum amount is 3.6 grams bought in a single day, or 9 grams in 30 days. Harris possessed 200 tablets that were at least 30 milligrams, which equals 6 grams. This is clearly over the legal limit for a 6-day because the legal limit is 3.6 grams, and he had 6. Thus, he was carrying an illegal amount of the legal drug. Thank you.
Thank you. Thank you, both sides. We will take this case under advisement. You are dismissed at this time. The second case that we will be hearing this morning is Florida v. Jardins. If the attorneys for those two parties would please come forward, we'll hear your cases. Is the attorney for the state of Florida ready to proceed? Is the attorney for Jardins ready to proceed? Okay. If the attorney for the state of Florida would approach the podium, you have the court's attention.
My name is Clayton Harris, and I will be representing Florida in Florida versus Jardins. After receiving a Crime Stoppers tip that a house in South Dade County was being used as a grow house, Miami-Dade Police Detective Pedraja and a drug task force, including several agents of United States Drug Enforcement Agency, DEA, conducted surveillance at 13005 Southwest 257 Terrace on the morning of December 5th, 2006. That morning, the task force was joined by K-9 officer Detective Bartlett and his well-trained drug detection dog, Frankie. Detectives Bartlett and Pedraja walked up to the driveway and front walkway of the house to the front door, with Frankie on a leash just ahead of them. While approaching the front door, Frankie was alerted to the smell of contraband by going to the strongest point of the source or odor and sitting down immediately. Detective Bartlett and Frankie returned to the car to get information for a search warrant. Meanwhile, Pedraja knocked on Jardins' door several times without response and claimed to have smelled the scent of live marijuana personally, confirming Frankie's earlier alert. He also noticed that the air conditioner was constantly running for over 15 minutes, which in his experience in dealing with grow houses is a common practice to counteract the heat from high-intensity light bulbs. Pedraja obtained a search warrant later on that day and returned to search the home. The search confirmed that the house was being used as a marijuana grow house, and Jardins was charged with drug trafficking and grand theft for selling electricity. The issue in Florida versus Jardins is whether a sniff from a drug detection dog at the front door of someone's home is a Fourth Amendment search requiring probable cause. In the three prior cases in which this court has held that a dog sniff is not a search, this court has emphasized that a dog sniff is unique, both in terms of the manner in which information is obtained and nature of the information revealed. Thank you.
You said that the fact that the air conditioning unit was running for 15 minutes was a indication of a drug facility? Was that the time?
No. It's in the experience with dealing with grow houses. It's a common practice to counteract the heat from high-intensity light bulbs, and also to.
What was the time frame? How long had it been running when he made that determination?
Well, the total time from when he came to the door, when he was walking to the door and went back to the car was 5 to 10 minutes.
Okay. Well, I grew up in Miami, and even in November, it's not uncommon to run an air conditioning for 15 minutes, so I'm not too concerned about that. I do wonder the expectation one has to privacy on their own home and the anonymity of a Crime Stopper tip leading to the search, the initial reason for them going to the property. What makes you feel like that justifies them bringing a dog onto somebody's private property?
Well, as to the latter point, this court has emphasized that a drug detection dog reveals only the presence of contraband and that no one has legitimate expression of privacy to that. And you can certainly put a no dogs allowed sign out front and there would not be complied consent. With respect to the state law, State versus Morsom, this was a case that came up during oral argument in the Supreme Court. It says that under Florida law, there is no reasonable expectation of privacy in a porch, taking into account that visitors and salesmen can come up to the front door.
So if there was a sign that said no dogs allowed or no soliciting, then that would have, in your mind, prevented a search?
Well, there would be no implied consent for that. And the police were lawfully at the front door, and that was established by the courts below. And the dog walked up the same way that a salesman would and alerted at the front door. He wasn't going all around the property. And I think everyone accepts that when someone comes to your door, they can avail themselves of their God-given senses, breathing in and smelling the air, as Officer Brajaha did. So not only did the dog smell the marijuana, Officer Brajaha did as well.
Justices? Any questions? Thank you. If the attorney for Jardins will please come to the podium, you have the court's attention.
Thank you. I am Nathan Ingram, and I am the attorney for Jardins in the case of Florida v. Jardins. On December 5th of 2006, they received, a month after they received an anonymous tip on Crime Stoppers, police, along with the DEA, came to the home of Joel Jardins and proceeded to go up to the front door and have a drug dog sniff on his property. The drug dog did not only sniff at the edge of his property, it sniffed right at the front door, as well as the police officer handling him, because he could not immediately smell it because there are mothballs surrounding the area, preventing the actual scent of the drugs from permeating the air around the house. I do not believe that a simple anonymous tip over Crime Stoppers would be enough to warrant a full-blown search and seizure, as I do not believe they had probable cause. And in the previous courts below, at first, they had determined that it was an illegal search, and they decided to follow Florida v. Rab, in which it was determined that in which they determined that any evidence determined and gained through an illegal search is not able to be used. But after they determined that the police officer had only come up to to retrieve the dog, they undid that decision.
So you're saying that it was an illegal search?
I am saying that, yes.
But do they have a warrant?
They did not have a warrant, nor do I believe they had enough probable cause to do that search.
Okay.
If they have an anonymous tip, how's that not probable cause?
I don't believe there was enough probable cause. A simple anonymous tip should not be enough to warrant a full-blown drug search on your property. See, no matter what, the case is merely to determine whether or not a drug dog search is limited to the cars. But if it is legal for a drug dog to come up to your property, no matter what, and simply sniff on the property, there may have been residual evidence. You never know. Besides, the efficiency of a Crime Stopper tip is not always as efficient as some people assume. It is not always correct. There have been many cases in which you have received they have received Crime Stopper tips in which the tip has been completely and utterly illegitimate.
You said that the dog sniffed it also from the front of the property to the front of the house. How far away would you be able to smell the drugs being made?
You'd have to be pretty close. You would have been pretty close because the mothballs were there are so many mothballs around the area. They were preventing the actual scent from getting anywhere further. And By the front of the property, I'm referring to the archway that led up to the front of the door, led to his exact front door. They could not smell any drug could not smell any drugs from the front of the street to the yard. He had to get as close as physically possible for the dog to get without breaking and entering. Pretty much.
So you're saying that the smell was not a probable cause?
The smell was not. No. I'm saying that they had no reasoning, nor did they have legal purposes to have a drug dog sniff on that property.
Okay.
Any other questions?
What do you believe would be probable cause for them to have this search?
I believe that enough probable cause would have been the anonymous tip combined with maybe a stakeout or proper examination of the area surrounding his house with an actual warrant to get a better search.
How many mothballs were there surrounding the house?
There were 3 to 10 mothballs in certain areas.
Is that an indication of the hiding drugs at all?
No. In many cases, there have not been mothballs anywhere near the front of the area of the house.
So they were in the back?
They did not.
Or the side? Where were they?
Mothballs are sometimes not even used in certain drug cases, in certain drug going areas. So it is certainly not a legitimate reason to just assume that drugs are being grown on the property.
For the anonymous tip, wouldn't they have to, for the anonymous, like the person who gave them the tip, wouldn't they have to have seen your client being, making the drugs?
Well, that is possible, or it could be completely and utterly false. The fact that there was an anonymous tip means that you cannot ask them and you cannot question, make sure that tip was completely legitimate. That person may just simply have said, I think that the drugs are being grown here. You cannot be sure whether it was completely and utterly reasonable.
But I think the chance of them finding drugs at your house is enough probable cause for them to go to your house, your client's house.
Yes, but they would not have found the drugs, and they would not have had the search warrant unless they had done the illegal dog search.
So again, subsequent evidence from the fruit of a poison search. So, all right, in the interest of time, we need to move on. We appreciate your time. Would the state of Florida like to rebut anything that's been stated? Okay, please proceed.
Okay, so as I said before, in 3 prior cases, the court has held that a dog sniff is not a search, so it wouldn't require probable cause anyway. And also, the purpose of the police going to the door was to walk up to the house, hope that Jardins answered the door, or hope that once they were up there that they would smell the odor of marijuana, as Officer Pedraja did, and that would not convert it to a search. And if it was a search if it wasn't a search for the police officer to walk up there, and then, Frankie, it wasn't a search for Frankie to walk up there. And also, you're using the drug detection dog to smell the odor of marijuana that's being pumped out of the house into the street. And the people who use the house know that. They know that, and we know that because the mothballs are present. And so, if they were to take off the mothballs, then the smell would get even further up the street. Thank you.
Okay, thank you, counselors. The court will now take these 2 cases under advisement. The United States Supreme Court is now adjourned.
All right. Welcome back to WA Live Court TV. Now, counsel, you heard the cases. Give us your take on what you think and how you believe that the justice will rule, given the arguments that the attorneys made. Who wants to go first?
I can start.
Okay.
In the Florida v. Harris case, I thought both attorneys did a really excellent job of representing their clients. I know we handicapped it before the presentation that Florida was likely to come out ahead in this case, but I thought Harris did an excellent job as well. She did a very thorough investigation of the facts of the case, pointing out statistics that we haven't heard here before, and I thought that was an interesting presentation. I thought she was particularly organized in her defense of why Aldo's search might violate the Fourth Amendment, despite the previous rulings of the court. So I would handicap this one as a toss-up at this point. It's for sure an interesting case, and I'm excited to see how the Supreme Court will rule.
So you think it's going to be a 5-4 decision on the Florida versus Harris case?
I'm not entirely sure of which way it's going to go, but I think very close either way.
All right. Okay. Mr. Batterman, please tell us what do you think about the arguments that were made in the Florida versus Jardins case? Which attorney arguments did you find most persuasive, and how do you think the Supreme Court will rule?
I think it'll be close. The arguments that dealt with the more general issue of dog sniffing or drug sniffing dogs, I think, are less relevant in this case than they are in the Harris case. So the decision will really hinge on whether the court thinks that individuals have a greater expectation of privacy on private property or in their home. I thought that the counselor for Florida did a relatively good job in their rebuttal of explaining that because of countermeasures taken by Mr. Jardins, it would have been impossible for the police to detect the illegal drug grow house without approaching the property. And I think that the justices might find that a persuasive reason to sanction more aggressive searches by law enforcement, because they don't want to basically give drug dealers or drug producers free rein to use mothballs or some other technology to shield their grow house. At the same time, I thought that the representative from Jardins did a reasonable job of defending the importance of protecting the privacy of the home and calling into question the motives of the law enforcement.
All right, thank you very much. Now, in the interest of time, we're going to have to suspend this particular case without having the judges come back in for a ruling. Thank you for watching WA Live Supreme Court Court TV, and we will come back to you at some other time and tell you precisely what the actual outcomes of the verdicts were. Thank you very much.